Right. So Mr. Lentz, we didn't have audio on him, so there we go.
Did you see the message change on the screen?
Yeah, that's my message. It'll go away.
Okay.
It always goes away. All right, Mr. Lentz. Okay, so hopefully someone's coming to help you. Yep. While he's fixing that, I'll be right back.
Got it.
Hello? Can anyone hear me now?
Yes, we can.
Okay,
All
yeah.
right. You good?
Yeah, thanks on that.
All right, Mr. Lentz, we can hear you now, so that's good. All right. This is in the matter of the people of the state of Michigan versus Gary Michael Lentz, file number 2023-21231FH. I have Jennifer Brugman, P66066, appearing on behalf of the people, and I have Logan Byrne, P8481818, appearing on behalf of the defendant. So, Mr. Byrne, this is your motion on behalf of the defendant to withdraw, please, so you may proceed.
Thank you, Your Honor. I know you've reviewed the motion, so I'll be as brief as possible. To give a little background, our claim essentially is predicated on the fact or on the claim that the sexually delinquent person statute is unconstitutional as it violates the prohibition against cruel or unusual punishment in Michigan. Mr. Lentz was charged with one count of aggravated indecent exposure. He was noticed with a sexually delinquent person notice as well as a habitual offender second notice. He eventually pled down in exchange for the sexually delinquent person notice and the habitual offender notice to be dismissed. So in Michigan, the Constitution protects cruel or unusual punishment. The U.S. Constitution protects cruel and unusual punishment. So our protections under Michigan law are broader than under federal law. And the test in Michigan is pretty well established. It's a four-pronged test. You have to look at one, the harshness of the penalty compared to the gravity of the offense, the penalty imposed for the offense compared to the penalties imposed for other offenses in the state, and then the penalty imposed in Michigan compared to what other states impose for the same or similar offenses. And then finally, whether the penalty advances the goals of rehabilitation. So those are the four things we have to consider. So for factor one, the severity of the sentence relative to the gravity of the offense. Of course, all sex offenses are very serious. I will say with his offense, it's a non-assaultive, non-penetrative offense. It's a high court misdemeanor, which normally carries a 2-year max. Once you add the sexually delinquent person notice, it elevates the offense. Well, it offers alternative sentencing path the court could take, whereas they could either sentence under the underlying offense if he's convicted, or 1 day to life, which essentially could mean he could either get out of MDOC or the jail immediately, or he could spend the rest of his life in prison. It's really up to MDOC and when they parole him. We would argue that the first factor weighs in favor of it being cruel or unusual because a life sentence for a possible max of life for a high court misdemeanor is never proportional to the offense. Factor two, you have to look at sentences imposed in the same jurisdiction for other offenses. Here we talked about a recent Supreme Court decision. Now it's not comparable like apples to apples because it talks about juvenile lifers. But last year, the U.S. Supreme Court ruled that juvenile offenders can never face, it's always unconstitutional as cruel or unusual for second-degree murder to be considered for life without parole. And now, obviously, that's because they're juveniles, and we know adult offenders, they can get life without parole for those offenses. But I think it's telling that the Supreme Court would rule that, you know, murder, one of the most heinous crimes you can commit, a life offense can be too extreme in some scenarios. And here we're looking at a high court misdemeanor. And again, we would argue that that isn't proportional to the underlying offense. Factor three, you look at sentences imposed in other jurisdictions for the same offense. Through all my research, I was unable to find another state with a similar sentencing scheme for the sexually delinquent person. There's some states where you can get life or very severe punishments for indecent exposure, but typically it's when you expose yourself to a minor child. And so I would say that those offenses are not comparable to the one here because we're not talking about child sex offense in those states. And some states are more severe than Michigan's 2-year max, but I would say most states kind of float around, it appears, that 1 to 5 year range as a max for indecent exposure. And again, no state carries a max of life for indecent exposure unless we're talking about involving minor children. And usually that's like a third or fourth offense. And then the final factor, the goal of rehabilitation, we would argue that 1 day to life does not promote rehabilitation. Essentially, you're leaving when or if ever the client gets out of MDOC in the hands of MDOC. And I would argue MDOC is not a place specifically designed for rehabilitation. I mean, we're making a facial constitutional argument here, but to talk about Mr. Lentz briefly, he's been serving over a decade. He's been denied parole on a case that had a 2-year minimum, and I believe he's serving a 20-year max. And it was pretty clear to Mr. Lentz, he's never going to get paroled out of MDOC. So when he was charged with indecent exposure notice of a max of life, it kind of left him with no choice, because he knew if he got sentenced to that max of life, even if it was a minimum of 1 day, it would essentially be a life sentence. And we would argue that because in order to find somebody sexually delinquent person, you have to find that they have compulsive and repetitive behaviors, which I would argue are typically associated with mental health issues. And those are the kind of people that MDOC are probably unlikely to parole. So would be guaranteeing a long, if not indefinite sentence. So finally, I think my arguments essentially come down to it's a high court misdemeanor. The possibility of facing life for a high court misdemeanor would never be proportional to the underlying offense. And then that would make his plea illusory, because the bargain he would have received would be less than what was intended, because he should have never faced the sexually delinquent person statute. And I would point the court towards People v. Williams, which is 153 Mich. App 346. It's a 1986 case, and the case that says, an illusory plea bargain is one in which the defendant is led to believe that the plea bargain has one value when in fact it has another lesser value. And then finally, just to talk briefly about the response brief that was filed by the people, I think the biggest contention between our two arguments is the people focus on the 1 day minimum, whereas we focus on the life maximum. Any defendant, since they're sexually delinquent, one means that someone would spend, it could mean potentially that someone could spend the max that life in prison. They say they could get out the same day. So I leave it to the court on which you believe is more important for the constitutional argument. I believe that's all my arguments, unless the court has any questions.
I do not. Ms. Bregman, I'm gonna pause for just a moment and I'll be right back. Let me back. Yes. All right, Ms. Bregman, you may proceed.
Thank you. I'm going to start with this, basically the second argument that of withdrawing the plea. It's based entirely on whether this court determines that the statute is unconstitutional, but the bottom line is that Mr. Lentz made a calculated decision and received the benefit of the bargain of the plea, despite any argument about the constitutionality of the statute. I would raise, for instance, the Stovall cases, where those defendants, even though that penalty provision of life with parole was deemed unconstitutional under the Michigan Constitution, and those defendants were entitled to resentencing. They were not entitled to withdraw their plea. The bottom line is the state of the law is what it is right now. Statutes are presumed to be constitutional, and again, as I briefed, the statute is constitutional, but that doesn't, but even if later or even this court determines that to be unconstitutional, does not equate automatically that the defendant's plea was illusory or he didn't receive the benefit of the bargain. Again, he would still be charged with a sexually delinquent notice in this matter. The penalty provision, if it's determined to be unconstitutional, doesn't take away the fact that that elevates it to a felony. He had a second habitual offender notice. Again, his plea was laid out on the record. There was no question. Yes, he brought up issues about that he thought he was he was making the decision because he knew the penalty was 1 day to life for the sexually delinquent notice, and he did not want to take that risk. That was a calculated decision on his part. Going to the crux of the case, as far as the constitutionality of 750.335A, the provision where the statute is 1 day to life for the sexually delinquent offender. I mean, I think I lay it out pretty well in my brief as far as all the four factors of the Lorenzen test. I would also note that when I was preparing my brief, Otis was down and I couldn't get access to a lot of stuff. So since I filed the brief, I have spoken with MDOC as well as received other information as far as how they handle these types of cases. And I have been advised by MDOC that parole consideration for 1 day to life cases are handled the same as all other indeterminate term of year sentences. So the prisoner is immediately eligible upon arrival, if that's their only sentence. I mean, obviously there's other cases where people have more offenses that they're serving time for. But if, for instance, they were only charged and convicted of aggravated indecent exposure with a sexually delinquent notice, they are immediately eligible for parole as soon as they arrive. Now, I've been told that those prisoners receive a 24-month parole term versus prisoners that serve life receive a 48-month parole term. They're basically, again, eligible for parole right when they get there. Now, obviously, they have to go through the process of being interviewed and things of that nature. But when I've been provided with about 6, I think, offenders. I specifically referenced Lonnie Arnold in my brief. I was able to print out his Otis as far as that he was paroled not that long ago, and not that long after he was resentenced to 1 day to life. Again, the whole premise here from the defendant is that because of the life tail, the argument is that it's automatically assumed that they're never going to get out. And that's not the case. If the court wants, I have examples of others where either they have been paroled already, they're on parole, or they're eligible for parole and of a certain date. And so I'm happy to provide those to the court, but obviously that is one aspect of the argument here, but I think it's the main argument. And so everything that I have come across actually counters what defendant's argument is. And so while it's an unusual sentence, there's no doubt about it. This sentencing scheme has been in place for a long time, and the legislature intentionally and conscientiously came up with it, and it has not been challenged because it's not unconstitutional. And these prisoners are given the opportunity to be paroled. And I guess for the most part, I would just rely on my brief. I think I lay it out. I mean, yes, there's some states that are more, they're not as harsh as Michigan, if you want to put it that way. But again, some states, they have a minimum term of years that goes beyond what our term of years is, and which is 1 day. So I do not believe that they've met the requisite burden to show a facial challenge or an as-applied challenge. I mean, I looked at this and I believe they are approaching it as a facial challenge, but it's certainly not unconstitutional as applied to Mr. Lentz either. So I would just rely on my brief. If the court has other questions, I'm happy to answer or provide further documentation if the court wants it.
Thank you, Ms. Bregman. Mr. Byrne?
Thank you, Your Honor. Just a few responses really fast. So when I was arguing that the withdrawal part, I just want to point out that I do agree with Sister Counsel that there was some benefit to the bargain. He didn't face the habitual offender notice, but that's not the law. The law for illusory plea bargains is not whether there was no benefit, but was it a lesser benefit than what was bargained for. And if the statute's ruled unconstitutional and that sentence, he would have never finished that sentencing screen, certainly he would have received lesser of a bargain. As it relates to the parole considerations she was discussing, I think it comes down again to what we were arguing, which is it's essentially in the hands of MDOC when and if the prisoners get out. I'm sure they provide like 6 different people, it sounds like, and everybody's situation is different. So that means everybody's going to get a wildly different sentence. And she did mention it's a 24-month parole term. So that means they're probably not, I'm assuming they're not going to grant parole on day 1, which means it's at a minimum, would likely be at a minimum 2 years, and then every 2 years they're reevaluating. As for the cruel and unusual, or as for the constitutional challenge to the statute, I just want to point out that I believe this is a novel challenge to the statute. For all my research, it was challenged, I believe, once as cruel or unusual, but because they were arguing that it was sentencing people for their mental health issues, and the court ultimately ruled that no, it was sentencing them for their behavior, not their underlying mental health, but they didn't actually address the sentencing scheme in that case. And of course, there's been a lot of recent litigation on how the sentencing scheme actually works, and Sister Counsel cited the Arnold case. And I would just point out that, yes, the statute has been around for a long time, but it's archaic in many ways. I believe, if I'm not mistaken, I didn't brief this, but the other two underlying offenses you can be convicted for as a sexually delinquent person are both you're acting sexually delinquent or assaulting another individual in a same-sex relationship. So the only three ways that you can be sentenced under the statute is indecent exposure, and then sexual assault between a man and a man, and sexual assault between a woman and a woman. And I think that kind of is very telling about when the statute was passed and the thinking at the time. And I think our understanding of mental health and how a lot of these things work is very different than when the statute was passed. So I think that's all I have to add, and I'd leave the rest to what I briefed. Thank you.
All right, very good. The original amended felony information from district court that was filed with the court on April 5 of 2023 had count 1 aggravated indecent exposure, which was a high court misdemeanor with a maximum penalty of up to 2 years and or a $2,000 fine. And then there was a sexually delinquent person notice for indecent exposure, which could result in a sentence of 1 day to life. A plea bargain was placed on the record when we were here for rearrangement back on June 30th of 2023. At that time, Ms. Underwood placed the plea agreement on the record. I questioned the defendant, as I always do, to make sure that they fully understand the plea. I found at that time that the plea had been given understandably, voluntarily, and accurately. He had full knowledge of his rights, and he did have competent counsel. The statute challenged on constitutional grounds. It's presumed to be constitutional and will be construed as such unless its unconstitutionality is clearly apparent. People v. Bronco 228, Mishap 649. It's a 1998 case. Thus, a party challenging the constitutionality of a statute has the burden of proving its invalidity. People v. Sados 283, Mishap 65. The court finds today that the burden has not been met, and therefore the defendant is not entitled to the relief requested. So, Mr. Byrne, Ms. Bregman, thank you. Mr. Lentz, thank you. Is there anything else we need to address today?
No, Your Honor.
And Mr. Byrne, you'll prepare the order?
Yes, Your Honor.
Okay, very good. Thank you all.
Thank you.